Hello, fellow Toolboxers. Welcome to episode number 357 of the Immigration Lawyers Toolbox podcast. Having a great recap of federal court cases for November 2024 with great colleague and fellow podcaster Kevin A. Gregg, Esquire, host of the Immigration Review podcast. And we're always happy he's here. He's always teaching a lot about immigration and CAT and all this stuff that I do not teach to depth. I just have a surface level knowledge of it, but it comes pretty in depth listening to this podcast. And I'm sure either you're into that kind of stuff and listening to this podcast is helpful, or if you're like me, you do a lot of USCIS stuff that doesn't get to immigration or humanitarian cases. It's good to know this stuff because you want to be a top lawyer. You got to know pretty much everything in immigration law. And speaking of knowing as much as possible, our live E2 case study. So we're not going to record it, so we can more openly talk about stuff in a small group setting, maximum 8 people. But I think 3 seats are already sold out, so I think there's 5 spots left. Or 4, people from the other session are wanting the previous one want to do it again. We have new people contacting us, so get it while it's hot. $250 for that session, $250, and you can make 10 times, probably 100 times. You get the E2 about that, and just do it right. So it's definitely worth it. And then more people want demand, reaching out, info@immigrationlawyerstoolbox.com. We'll just do more with folks like NIWs, E1As. There's all these cases that people want to learn, and I've been wanting to make full-on courses, like my marriage green card course, which is like 18 hours. But that's a big piece of pie to chew, or whatever saying I'm making up. So but maybe bite size makes it easier for people like this. So we're going to do it and see how it is. And the second thing is the AI. If you didn't hear last thing is I'm getting using the AI to review AEO decisions, spit it out in more conventional, smaller packets, just like, I guess the theme of today's show is smaller bites. So then you could dig deeper if you find a case that you need. And also make it more searchable. And the searchable aspect we're still working on, but also a podcast format, a new podcast where we just have the AI speakers talk about these cases, so you can do it while you're driving, you can listen to it and analyze, hear the analysis of it. It's pretty good about what's important, what's not on the AO decision, what criteria met, what jobs were presented, all that kind of stuff. We're doing it on talent-based immigration first, EB1A and NIW01s. And if you're part of the circle.so community page, it's free for lawyers. Just email me with your bar number and your name if you're not already a member. There's a tab on the left side that says talent-based immigration. I'm going to have the link to the podcast there, and I'll be uploading the PDFs and stuff there, plus the Excel sheet that lists like a table of contents of what jobs there were, was it approved, and what criteria argued, so you can quickly find what you need. Having said that, nothing in this show is intended as individual legal guidance. Please consult with an immigration attorney if you're interested in immigration law or using it or whatever. But y'all know that already. Let's get the show started.
Kevin, Greg, brother, good to see you again.
Good to see you, John. Happy December.
Happy December. I'm glad we got the microphone situation fixed. It was more of a software issue with the provider that we have, but I'm glad we were able to hash it out, figure out what the problem was. You sound so much better.
You didn't have to say that. Nobody would have known.
Maybe, but I'm like, I have to listen to it myself. I'm like, the last 2 months, I'm like, what's happening? I'm like, oh yeah, the same issue with my mic is probably happening on your end too. It uses Chrome as well, so we can't use Chrome. But that's a little behind the scenes for everybody. December's here. We're going to go over November court decisions. Obviously, the craziness is just beginning. You've heard obviously about USCIS saying immediately they want all cases filed the medical checkup without any notice. So people filing on December 2nd, all of a sudden are like, oh, we can't file. We have to get notice. So the craziness begins even before it begins. But how's the news out in November for court cases?
It's good. I saw that about the USCIS thing first. I wonder why. I don't think it's designed. I don't think USCIS, even under the Trump administrations, I don't think they do things intending to necessarily screw non-citizens all the time. Like, I think there's usually a method to their madness. Even the NA thing with the forms, I feel it was done because someone at USCIS had run into some ambiguous issue in the past. Who knows? But, practically speaking, that NA thing really screwed non-citizens. I wonder why that announcement with the 693. I wonder if they intend to approve lots of the cases, for example, before Trump comes into office, or if they're afraid that like Trump will take away the 693s are good forever change, but like if it's filed before that, then whatever change he does won't apply. Like maybe it's good for non-citizens. We're always so harsh to
I mean,
to
give
roll
like
our
a
eyes
week's
at you.
notice because I have like you have deadline cases you got to file, and
Right.
you.
Well, that's fair.
I'm just saying,
There's
like,
they
give
should
me
give
like
us
3 days
more notice.
notice or something. Don't just bust it out
Right.
on us. Give 24 hours notice, like that. That's, I mean, so the lack of notice is just insane,
That
like to
is
me.
true.
But
No,
there
no.
may be something, but it's just like come on now, just work with us a
I
little
can't argue. I
bit.
can't argue with that. I've tried to defend USCIS as much as I'm willing to do on your show.
Fair enough.
um, I always pick the what I think are the good, the non-citizen good cases from the prior month. I got a
Mhm.
bunch to choose from. Some better than others, some adverse. I never talk about them on your show. I thought that these ones were interesting. I got like two and a half for you. First is Farhane v. United States out of the Second Circuit en banc on October 31st, technically, but it's a November case because that immigration review episode published in November. And, the Ninth Circuit's the only circuit where when they do en banc, it's not the full court. Every other circuit, to my knowledge, is literally every judge on the court. So this is the full Second Circuit overruling Farhane v. United States, which I had done like 100 episodes prior, which is always amusing to me. Like, and I try to go back and like see what did I say the first time? Did I call it like that? This is not, and I did. In my defense, I did on Farhane. And when the first Farhane, I'm like, this is weird, guys. What are you doing? And it's about denaturalization and ineffective assistance of counsel in Padilla. And the full Second Circuit, with a dissent, but the full Second Circuit said essentially that if criminal counsel doesn't um, advise of the immigration consequences of a plea, then there is an ineffective assistance of counsel claim lying there such that you can get that conviction vacated before or alongside the U.S. government's attempt to denaturalize. Like that's already the case when it's removal proceedings, right? If an LPR accepts a plea, then and they weren't advised of the immigration consequences, they were affirmatively misadvised. That's a Padilla v. Kentucky Fifth Amendment violation, Sixth Amendment violation. I'm sorry, that then has effects because they were subject to removal. But in the DNAT's context, what happens when the U.S. citizen takes the plea, but then it subjects him to denaturalization? That's a very difficult and interesting fact pattern, but it's something we're going to be seeing a lot more under Trump too, with Stephen Miller's already bragging about their denaturalization task force like they did last time, and they always focus on these conspiracies, these conspiracy convictions, because those are the easiest types of things to denaturalize someone for, because like the conspiracy always begins before they became a US citizen and ends after they became a US citizen. And in their plea deal, they admit to the years of conspiracy. So they are essentially admitting that they were committing criminal conduct while they were in LPR, which they, of course, did not disclose in their naturalization application, thereby making a pretty easy case to denaturalize them. Because, the N-400 and the oath ceremony asks, have you ever committed criminal activity they haven't been arrested for? And here they are pleading to literally doing just that. In this case, the guy was giving money to the Mujahideen in Afghanistan
Boy.
and Chechnya. And they got him for money laundering, and then it just so happens to be to fundamentalist Islamic fighters as well, and he pled guilty to it, and then immediately tried to get it vacated. Like, I was never advised. Because he became a citizen, they tried to denaturalize him for it. And it's not just affirmative misadvice from the Second Circuit. Quote, silence on the subject breached the Sixth Amendment duty to advise, end quote. And criminal attorneys with a criminal case for a citizen, I think a lot of them aren't going to be advising of the immigration consequences. They're not going to be thinking that this could subject them to denaturalization. So this might be more prevalent than one would think, and it's really something to know for the coming Trump administration, again, when they're going to be beefing up this alleged denaturalization task force. Quote, to provide effective representation, counsel must advise her client as to the paired set of serious adverse immigration consequences by at least flagging the risk. As many have observed, the risk of banishment may weigh more heavily in a criminal defendant's assessment of his options than any particular sentence of incarceration, end quote. So even though he admitted it in the plea agreement, it looks like it's all going to probably be vacated. And, the U.S. government can seek to denaturalize him again. You don't need a conviction, but they're not going to have very good evidence, right, if he doesn't have the conviction for conspiracy. And in denaturalization, it is the U.S. government's burden, and it's a heavy burden at that.
Yeah.
So it's important stuff. Just a note, in the 11th Circuit, and I don't remember the other circuit. It might even be the Second Circuit. There is case law that is very interesting that says if you are convicted of an aggravated felony as a citizen and then you are denaturalized, you can't be removed because the removal provision for aggravated felonies requires that it says any alien convicted of an aggravated felony. And if you're convicted as a citizen, you're not an alien convicted of an aggravated felony. It's the Hilton decision out of the 11th. I can't remember what the other, I think it's the Third Circuit actually. But again, that's also prevalent in these cases because it really is, it's usually a money laundering conspiracy, let's be real. And that's an aggravated felony. So even if they succeed in denaturalizing these people, it won't make them removable once denaturalized because they were citizens when convicted, even if they were green card holders when it began. Pretty interesting, right?
Yeah.
But of course, they can't travel because once they revert back to being a green card holder, it's probably also a CIMT. So when they travel, come back in, they can be deemed an arriving alien, and then they're really in deep trouble. But still, right? Interesting stuff.
Yeah. Very cool. You have to read. You have to read the text and play the word he gives. Yeah.
Any alien, yeah. I mean, 2 circuits, and it's based on again, this is separate from Farhane, but it is the thing. It is the case with Farhane. I think it's the Third Circuit, so the Second Circuit wouldn't have that law. But Mr. Farhane, it's a 101A43D money laundering aggravated felony. It would be the same thing if he is denaturalized eventually, even though what he pled to is a per se aggravated felony. It wouldn't make him removable in the 11th and the Third Circuit, I believe third, because of how the removability statute is written. But he doesn't want to be denaturalized anyway. A separate federal court proceeding, of course.
So if a person, they would revert back to LPR, and then he said if they travel, they'll come back, they'll be arriving alien.
They could be treated as an arriving alien. That's up to the border officer.
But even here, when they go to renew, they could always NTA him for something, like try to fight him out, right?
You couldn't. That's what I'm saying. You can't. Not in the 11th, and again, I think the Third Circuit. There's no ground of removability. Let's just talk about the 11th Circuit, even though there's another circuit. Let's say Farhane was in the 11th Circuit. There is no ground of removability that would be applicable to Mr. Farhane that I can think of if he reverted back to a green card holder and never left the U.S. It would just be aggravated felony. Now, his conviction, the statute, per se aggravated felony, literally 11843D is, money laundering conspiracies under, 18 USC section 1956 and 1957, the classic money laundering conspiracy. That's literally what he has. That's what an aggravated felony is. And of course, LPRs who are convicted of an aggravated felony are removable. But again, the aggravated felony removability provision only applies to aliens convicted, and Mr. Farhane was not an alien when he was convicted. He was a U.S. citizen.
Would they?
And so, to be removable for being a CIMT, you have to be 2 or more CIMTs not arising out of a single scheme, or a CIMT committed within 5 years of obtaining LPR status. So, assuming those things don't apply, not removable.
Well, they would get it for misrepresentation. Say they did misrepresentation on the N400, and
that's not a ground of removability.
It's inadmissibility. Aren't all inadmissibilities also removability too?
No. And in any event, a misrep on an N400 doesn't make one removable.
Really?
Inadmissible.
Huh, okay.
I'm pretty sure of that latter thing. in any event, not all inadmissibility provisions are removability provisions, and there is no misrep removability provision. The only misrep removability provision is if you were inadmissible at the time of adjustment for a misrep.
Yeah.
But that's not the case here. I mean, if he had, if he had committed this criminal scheme before he even adjusted, yeah, then you've got a bigger problem. Then you've got to lie in your I-45.
Yeah.
But
I've had a consultation yesterday that was somewhat similar, but they did the crime they weren't caught for before adjusting, and he didn't mention it at the time. It was a false claim too, but it was false claim back in like 80s before it was like false claim was a charge. So they
that's
cleared the false claim, but they still have a misrep. So that's a
right. Yeah, no, misreps on 45 is very difficult to get around, but
yeah.
a misrep in an N400, not really
Yeah, that's
a
what
removal. I mean, it
don't
can prevent,
naturalize me.
and yeah, it's 5 years too. I mean, you try again 5 years later, so long as you're not removable. But interesting. And I love it. It's textualism. Again, this is not Farhane. We're far away from Farhane, but the Hilton decision out of the 11th as just one example. I mean, it's textualism. The statute says what it says. It says any alien convicted of an aggravated felony. Not any U.S. Not any person, not any U.S. citizen, any alien. So remember that again. If they're coming after your clients for Trump round 2 and the denaturalization task force.
Did you last time around? Did you run into cases from the denaturalization task force?
We had a few.
How? Because it sounded like by the time it was getting up and running, they changed,
Yeah.
and it seems like USIs themselves were kind of like throwing stuff in the gear. They didn't want to really get something like that
Well, it's
going.
so expensive. I mean, it's so expensive. Oil doesn't like to have the burden.
Yeah.
Like, why? There's they never have to have the burden. They always
Yeah.
get to play defense. We always have the evidentiary burden. Denaturalization, it's expensive. It's difficult. It's serious. I don't think judges like it
Hmm.
because you're taking away someone's U.S. citizenship, and that's why these money laundering conspiracy type offenses are so appealing because they plea to a time frame. They just the complaint just connects the dots in
Yeah.
like 6 pages. Very easy.
Well, that's why you get the Biden pardon that says anything from 2011 to 2004.
Well, yeah, you need to get a pardon. That's right. You need to get a
Yeah.
pardon.
The special Biden pardon. All right, cool. Thanks, man. That's interesting stuff. What do we got next?
Reed, staying with the Second Circuit, Reed v. Garland. It's about mental competency. And, there used to be all the rage when I was an attorney advisor in immigration court. It was like towards the end of the Obama administration, and they were just putting these things, matter of MAM, matter of mom, had just been issued recently, and what safeguards are due in immigration court. By the way, survived Trump 1. I expect it'll survive Trump 2. That is, giving attorneys in removal proceedings to those deemed mentally incompetent and requiring these safeguards.
Interesting.
And in this case, the immigration judge essentially messed up, said the Second Circuit, because everybody recognized that Mr. Reed was not competent to represent himself. He was deemed incompetent. He was, schizophrenia and all the serious things. And there was a finding that he was not even competent to assist his attorneys. But essentially, the immigration judge did what immigration judges often do, and they say a bunch of stuff, and they say, "Well, Mr. Reed has the ultimate safeguard, an attorney," and they were good attorneys, it would appear. But like, if you can't work with your attorneys, how good of a safeguard is just having an attorney? That's paraphrasing the Second Circuit. But also, what the Second Circuit said is the IJ needs to make specific factual findings as to the degree and scope and character of the mental incompetency, and then explain what safeguards were implemented to account for all of those incompetency issues. If they don't do that, says the second, it would appear, they're not eligible to ascertain whether appropriate safeguards were implemented, right? Because you got to first say what all the problems are and then say how you're accommodating all of those. In this case, for example, they were saying, well, maybe you could have ordered a social worker, had a social worker get in to help him for many months, help him remember certain facts, because this was actually about former Section 212C relief, and his remembering and working with his attorneys actually was very important for his substantive eligibility for that relief, and he was not able to do that. Quote, to order the removal of someone unable to participate meaningfully in his or her removal proceedings without adequate safeguards would make the whole process a charade, end quote. So, big deal stuff. Also, another quote, for termination generally, which again might be important for Trump round 2 for us immigration attorneys, not just for mental incompetency. There are a bunch of regulations, and a lot of the regulations that are there are for EOIR are designed to protect constitutional rights, like due process rights. And quote, whereas here, a respondent claims that an agency failed to adhere to their own regulations regarding a fundamental right derived from the Constitution or a federal statute in a deportation hearing, he is not required to make a showing of prejudice before he is entitled to relief, end quote. That's a big deal. Quote, for us who practice in removal proceedings, it's not necessarily the law in every circuit as I understand it, but, that's how they try to get you when you're trying to terminate. They're saying, well, okay, there was a violation by ICE or the immigration judge. I'm not saying, that they were doing it intentionally, but it did happen. But it didn't prejudice your client because it would have been the same result anyway. You know what I mean?
Yeah.
Like that kind of rationale. And when the regulatory violation is designed to protect these fundamental rights, or even another federal statute, a right derived from federal statute, no prejudice is required. I mean, that's just flat out, you're entitled to relief, which is often, termination. So, Reed v. Garland, another important case out of the Second Circuit. I guess November was the Second Circuit's month.
Very cool. A second case. It's a bit of light because I get the notification for federal court cases. Not that too many popping up right now. No.
November. I mean, I could count in immigration. Let me do the counting in real time. From the episodes published in November, there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15 cases, including the BIA's cases, precedential decisions in November. So that's pretty light. If you divide that by 4, that's only like what, 3.5 a week. I'd say that on the podcast, the average is 4 or 5. So November a bit light. 1 case last week over Thanksgiving. I'll take that.
You go in your podcast. You go over every case.
Every precedential immigration decision.
See, I got a notification. I was light. It was like 3 cases a week recently, but usually it's like 5 or 6, maybe 7 if it's really heavy. Yeah.
Yeah. That's about right.
Okay, cool. I keep up on the
Last
stuff too,
one out
not
of
the
the
depth that you do, but I gotta keep my eye on what's going on. As soon as I see it says cat, I just skim through it though. It says CAT. Okay, I'm gonna next case.
Cat's the last refuge of a scoundrel. Is Cat. Sang-Yup Kim is killing it with Convention Against Torture case law out of the First Circuit. Yeah, Sang-Yup's made some excellent law in the First Circuit with the ACLU New Hampshire, and not just on Convention Against Torture, but so often I see these First Circuit decisions where like really smart arguments are rejected, sometimes again accepted, but rejected, but then he'll get a win on Convention Against Torture deferral because he's really good. So it's amusing. Cool. The last one I have is out of the First Circuit, Diaz-Valdez v. Garland, on November 22nd. Not going to get into it all. I mean, the non-citizen's attorney on a BIA appeal were 1 day late, which is always horrible.
Yeah.
And so the BIA said they missed their deadline on the notice of appeal. But the thing is they apparently used, next day FedEx delivery, sent like 4 days before the deadline.
Ooh,
now, in between that, I think was 3 days of weekend and a holiday. So not great. Don't get me wrong. And so it arrived 1 day late, but it was next day. And like 2 things there. First, the First Circuit is saying, look, you get 30 days to appeal. And of course you can't wait 30 days if it's in the mail, but because you got to send it. But the 30 days is there for a reason. This isn't a footnote from this decision. Like the non-citizen doesn't have to, they don't have to file on day 2. Like you have to consider whether you want to appeal. You know what I mean? That's the point of the 30 days. Mm-hmm. So keep that in mind with the diligence concerns. But this one, it was essentially a factual dispute. Did they send it when they said they did? And they provided a lot of evidence, that is the attorneys, that they sent it 4 days ahead of time by overnight mail. And the First Circuit said there's enough evidence here. The BIA should have accepted this, essentially. But I really like this quote. Quote, well, first of all, I'm sorry, let me step back. The BIA itself, in their decision matter of Morales, said, like, you should use overnight FedEx or UPS or DHL. And so that's what they did here. So when you're doing that and the BIA says you should do that, like,
Yeah.
you should excuse them. But the quote that I'm looking for, give me 1 second,
Sure.
which I just love, and I put it on my social medias as well, is, and I need to get the good quote right. Oh, here it is. Quote, importantly, an attorney's representation to a court that they sent a filing on a certain date is generally accepted as sufficient to establish the date of mailing. Courts around the country routinely rely on such representations. End quote. And it would appear not even an affidavit form, just like the attorney in their filing saying, I sent it on this date. Now, you're an officer of the court, the First Circuit is saying. Generally, that's accept. We're officers of the court. I mean, use that power wisely. Quite frankly, it's best practice to put it in an affidavit. Don't get me wrong,
Mm-hmm.
but like that's a big quote for anything really.
Yeah.
When what the attorney did is important. Here is the First Circuit saying correctly, like we're all attorneys. What attorneys say, like we all have an oath. We all have a responsibility of candor and honesty. So
Cool.
important
That's good.
stuff.
Reasonable. Being reasonable. That's good. Well, good
Yeah,
stuff.
sorry if I don't have as much energy as usual. I know, I mean, I got a lot of energy, but like as you know, I've got a pretty young son, and I think it is starting to take its toll. I don't have to tell you,
How many months
but
has it been? How old is he? How many months is he?
3.5 months.
Oh yeah, the 6 month mark where the pure fatigue starts kicking in. You have some sort of
Six. It gets worse. 6 months is bad.
if they don't sleep. 6 month mark is when you expect them to sleep, and if it goes past that, they're not. That's when like the natural DNA that gives you this energy to keep going is like, wait, what's going on? Still no sleep? How is the sleep working for
The
you guys?
sleep has been good, but I feel like there's regression, and all the things I've read is it
Yeah,
does start to do that at this time.
yeah. There's regressions. They change. They start sleeping during the day a lot, not at night, or vice versa. So, 3 months to the 6 month mark. If yeah, it's hard having kids. And that's why people human race is going extinct. We aren't having enough kids. Everyone's like, yeah.
I don't think I'm helping either though. Like he wakes up, he's crying. It's 3 a.m. and I get in his face and I just start screaming in his face to go to sleep, just like yelling, "Just go to sleep!" You know, shaking him, screaming in his face. No, just kidding.
Well, after the year, that's gonna happen.
Right. You're
And
like, ha ha ha,
uh,
totally
yeah,
kidding.
I had to like just drop my little cry, go in a set corner room, pray, and that's why I made me really religious after that. It's been a year now since I just learned how to pray, get over stuff, but it happens, man. Luckily, I've like, so you have to have support. That's why I mean, it's, you're joking, but it's a, it's a big problem as people do get messed
Yeah,
up like this. There's a beauty to it too. It's a method to the madness.
absolutely. Well, those are the three cases I've got. Interesting, all with good guidance for the coming fights of Trump too that are coming our way. All pretty relevant. Again,
Yeah, I was having a
uh,
TPS consultation an hour ago, and they're like, "Well, what's gonna happen?" I'm like, "Well, last time you guys fought the TPS, so your team on Haiti, and you pushed them back. They wanted to get rid of that. So
we're gonna do it. We're gonna do it again.
yeah,
Not just us, Mayor. Big firms are already indicating their support should the Trump administration do what they did last time, which was not follow the Administrative Procedures Act and terminate TPS for countries like Haiti for racist reasons, as Judge Kuntz said in the Eastern District of New York. So if that does happen again, there is the teams are already starting to congeal, and I mean I'm sure ACLU's got their plans too, just
hmm
like they did last time.
yeah.
Southern Poverty Law Center, I think, is out of the game. I think
They bankrupt got sued or
they
something, right? Or,
no, I think they took. I don't know what happened, but I think they took away their immigration department. But a lot of those very smart people have gone to other immigration advocacy groups.
oh, interesting.
Curious what Sui Chung will do with AIJ in South Florida. I know that they are ramping up their litigation department. AI Justice and Sui Chung is now taking the helm of that. So there are fighters. It'll happen again. That we are more organized this time, but so are they.
Yeah.
So we'll see. We're gonna see what happens.
In 4 years, he's supposed to have 4 years of training and preparation. Oh
Oh
man.
God.
Well, it's good to have a podcast during this time. Our ratings, CNN loved Trump because it brought ratings, and it definitely helps our ratings too. So, my
I'm not
viewership
gonna.
on my social media, everything's going
I
double,
refuse.
triple.
I'm not. I'm not. I'm not. No. 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 I'm not. I'm not following that.
It's
Although it's probably true,
it
but
just
I would
it
much rather have a sane
no
system
for
that I don't have
sure,
to.
but it does help the numbers.
I refuse to see the. I refuse to see the bright side, John. I'm still in mourning.
I'm getting like viral TikToks again because like my TikToks like they get 10,000, 20,000 views, but I got like a 6.5 million one. I got another one 200,000.
Good God.
Yeah, just talking about immigration stuff because now people are paying attention again. So all my like my it gets gung ho. Not that many leads come in, low quality leads, but like because people just ask like, hey, how do I come to America? I'm like, okay, that's not going to go anywhere.
Yeah.
But it feels good to have this video that gets 6 million people to a certain extent.
I should get on TikTok.
It devolves into like fighting in the comments. That's why I get so much. I debate whether I should delete it because there's people like pro-immigrant, anti-immigrant, racist people, whatever, just fighting in the comments. And I'm just looking. I'm like, why would you fight in the comments section of a random TikTok? Who would do that? Like,
Look, John, I can do it though. Like, look, this is a thing, right? They do this, and then you have like something written on the top. I've seen the reels, and then you go like this,
yeah.
and you go like this. Like all good millennials, I don't see it on TikTok. Actually, I see it 2 weeks later when they post it to Instagram.
That TikTok is good, man. It gets the word out there, but yeah, low quality leads and a lot of nonsense. Like, yeah, no, like the same video on Instagram, no one comments on, but on TikTok, it's just fighting and stuff like that. It's just stupid. But we do this stuff to get business, to get the word out too at the same time. So 2-for-1 deal for us. Thanks for coming on, Kevin. I really appreciate it. We'll get this one out, and I guess next time I see you, it's gonna be New Year's. We're probably gonna push back the recording because it's gonna be right after New Year's, probably too busy, but we'll connect on that. Happy New Year's, Merry Christmas, Happy Hanukkah, and
To you as well.
thank you, brother. So I got a live show I got to do for my other thing. I'll stick around and talk. Well, let's go offline. We'll talk 5 minutes and we'll go. But thanks everyone for listening. Kevin, Gregg, obviously, Kurzman Law Firm, big player in the game, immigration review podcast. It was this week I was checking out podcast iTunes listings. You jumped ahead of me, or you're way up there. So recent podcast did really well. Very happy about that.
Sean.
Keep up the good work.
Awesome. Kevin is really good. I can't say enough good things about him. He's very helpful. Even behind the scenes, I reach out to him. He's always very kind and gracious with the information he helps. It's good to have a partner of the Kurzman Law Firm in your have a direct number to the partner at the Kurzman Law Firm. It's always a good thing. So if you're interested in the E2 course I mentioned at the beginning of the show, just hit me up, info@immigrationlawyerstoolbox.com. There's a lot of demand for it. It's a really fun course. I'm like, I wish this stuff existed when I started. It would have really smoothed things out. But we have that there for you. January is like third Thursday of January, I think. I got 16th or something. I got to check. But if you're not part of our newsletter, join. Just email me if you're a lawyer, or even if you're paralegal. But you'll get it because I have these updates there. I write it out, and you'll get it. You can reply to that and sign up for stuff much faster because you get first dibs at this information that comes up. As well as the AI stuff, you just need your email. No one needs to know your lawyer. Get your email. You'll get access. Not only the AI stuff I'm working on, but hours and hours of CLE, free CLE stuff on all sorts of stuff about immigration law, about business practice management, marketing, all the like. So it's in a discussion page where you ask questions. We're trying to get away from Facebook because we don't know what in the world's going on there. And it's so hard to find. You read something on the Facebook groups that's really interesting. You want to go back to it. You're never going to find it again. But we have better systems on Circle that is our community page. So just email me info@immigrationtoolbox.com to join. Having said that, have a good one. Bye-bye.